Today I want to talk about two personal injury cases which I have come across there in the last couple of days. The most recent one is reported in today's Irish Times, and this reporting is from the Irish Times. The heading on the article is "Judge Dismisses Outrageous €60,000 Claim Taken by Woman Injured Working at Dublin Airport." The lady's name is Olga Dresmane, that's Dresmane. She's 49 years of age. It's alleged that she took part in a road race weeks after suffering a knee injury while doing a security job. But her claim was up to the value of €60,000 or thereabouts. She was a Dublin airport security officer. She was alleged to have taken part in a road race weeks after suffering a knee injury. This has been described by the judge as outrageous. He says in the Circuit Court, "I've no doubt whatsoever that this case has come to court with a view to maximising her claim for damages," Judge John Martin said. She had set out to deceive every medical expert with the sole intention of increasing her damages award. And he said that what Miss Dresmane has done is outrageous. He threw out the proceedings and ordered her to pay the costs of the case. Her name appeared on a list of runners participating in the mini-marathon 11 weeks after her accident at the airport. She claimed not to have run in it, but was photographed in an 8-kilometre road race in Clontarf shortly afterwards. Judge Martin handed Miss Dresmane a laptop with a zoomed-in picture of a woman kitted out for racing and asked if it was her. Having examined the photograph, she replied, maybe. She denied having participated in a 10-kilometre mini-marathon in the Phoenix Park, but said she attended the event with her daughter and walked a circuit with her. She was out of work for 2 years. She had deliberately misled the court over the extent of her injuries, according to the defence legal team. She was responsible for x-raying luggage at security points in the airport. She injured her left knee when a piece of carry-on luggage was accidentally dropped by one of her colleagues. In his judgment, he said that Miss Dresmane's employer, ICTS Ireland Limited, conceded liability for her injury, and the court at this stage was simply assessing the damages due. That's an important point to bear in mind. There's no contest here, no question about liability, because her employer accepted and admitted liability. The only reason this was in court was to have the extent of the injuries assessed. The judge says an unusual feature in this case is that every single doctor involved had a difficulty understanding the length of time her injury had persisted. Judge Martin said the fact that the doctors had difficulty understanding her ongoing pain for 4 years after the April 2018 incident raised a red flag to the court. He said, and if that red flag wasn't flying high enough, and then presented with evidence of her part in sporting activity following her accident. He dismissed the case, and he said it was a matter for ICTS Ireland to decide if there should be a follow-up to his ruling on the evidence presented to the court. I think what he's suggesting there is that the employer may wish to take action, disciplinary action against the employee on foot of what appears to be essentially a fraudulent claim. Basically a claim that has been described by the judge as outrageous and which has been dismissed and thrown out, and the costs have been awarded against her. That's one personal injury case. The other one is one that I came across yesterday, and I think, if memory serves me right, that it was a case where there was also an admission of guilt, but the judge told not an admission of guilt, an admission of liability. The judge in that particular case described the claimant, the plaintiff, the person bringing the claim for the personal injury, as over-egging the pudding, Psychologist accused of over-egging her pudding as €60,000 injury claim dismissed. So this too was dismissed. A judge has dismissed a $60,000 damages claim taken by a psychologist against Trinity College Dublin after finding that she over-egged her pudding and exaggerated the extent of her injuries. This is the same judge, actually, again, Judge John Martin. So I'm sure there are people out there who would be campaigning against increased insurance costs for small businesses and for employers and so on. And I'm sure they are all cheering and saying fair play and amen to Judge John Martin. He threw this case out as well. Judge John Martin ordered Blessing Agbo from Newbridge, a former psychology student at Trinity, to pay the university's legal fees in a case. This case, like the previous case I've just discussed, sees the plaintiff, the claimant, having costs awarded against her. Miss Agbo, 50 years of age, she told defence counsel in the circuit court that she'd bounced down a flight of wet steps after leaving a lecture on the college campus in February 2017. She told Judge Martin that Miss Agbo had told, Mr. English, who appeared for Trinity with Kerry Lyons of Ennis Solicitors, told the judge that Miss Agbo told different doctors she had bounced, cascaded, tumbled and fell head over heels down the steps, injuring her foot, ankle, lower leg, hip, back and shoulder on her left side. She claimed that the injuries were such that she had to use a crutch and wear an orthopaedic boot for up to 2 years and had difficulty being intimate with her husband. Again, this is a case where liability was admitted. Judge Martin was told that Trinity was admitting liability in the case, but was questioning the claimed extent of the injuries in a hearing to assess damages. Again, this is only a case to assess damages because the defendant in the case, Trinity College, admitted liability. Cross-examination drew to a close. The court was shown a video of the mother of four walking unaided from her home to her car without her orthopaedic boot or crutch, but then arriving at a consultant's clinic with a boot on her foot and a crutch in her hand as she exited the car and limped into the surgery. Other videos played to the court showed Miss Agbo running, walking, stooping and bending without apparent issue and lifting several large shopping bags into the boot of a waiting taxi. She told Judge Martin that she sometimes was able to walk unaided when she took pain-killing tablets and because of the exercises and ongoing physiotherapy. The judge threw the case out. He said the court did not know from Miss Agbo's evidence if she'd fallen down 4, 12 or an entire flight of steps. He said the fall was undoubtedly painful and she was taken to hospital by ambulance. He said an initial medical report suggested that recovery could be made within a matter of months, but it was difficult for the court to determine on the basis of our evidence whether the injuries had persisted in the long, medium or short term. He said basically that Miss Agbo had over-egged her pudding and in cross-examination affirmed that for the best part of 2 years she required the use of a crutch and orthopaedic boot when this was clearly not the case. He said the video footage clearly showed that she had no difficulty with day-to-day activities as she had claimed. The judge said it's most unfortunate that she sought to present her case in the manner in which she has done so and has basically flawed her own claim by her evidence. Judge Martin said, I believe such is the extent of exaggerating and over-egging that she's left the court with no alternative but to dismiss her claim and I award costs against her. That's Judge John Martin. I think he's in the circuit court and he has dismissed both of those cases that I've covered just now, discussed just now, and he awarded costs against both plaintiffs, both claimants. So there you go. Let's hear it for Judge John Martin when it comes to claims that are either over-egged, exaggerated or are essentially try-ons. Hope you find this video informational or informative rather, useful, serviceable, of some utility. If you do, I'd appreciate if you gave it the thumbs up down below, and you may be interested in subscribing to my YouTube channel. I'm heading for 20,000 subscribers now on YouTube, and I'd like to give it a boost and get there as fast as possible. So hit the subscribe button, hit the like button. Thanks for watching.